Yeah, today the Supreme Court's decision today in the healthcare cases is one of the really big days in Supreme Court history. I'd say in the last 20 years, it's hard to think of a bigger day for the court as an institution. Obviously, the big decision the court rendered today was to uphold the healthcare law almost in its entirety. And that's very big news, obviously, for the administration. It's big news for people who are opponents of the healthcare law. For anyone who's interested in the Supreme Court and the law generally, this is important news in a number of other ways, too. It says a lot about Chief Justice John Roberts because he was the crucial vote in the 5-4 decision to uphold the law. And that indicates that he has a certain vision of himself as Chief Justice, a long-term vision concerned about the standing of the court, and certainly dispels any notion that Chief Justice Roberts is driven by any short-term ideological or partisan motivations, because just, in the natural tendency of his ideology or predisposition was probably to be skeptical of the healthcare law. So that's important. It's also interesting because the justice everyone thought would be the swing vote in this case, Justice Anthony Kennedy, turned out not to be the swing vote. In fact, he was strongly in dissent, kind of reflecting the fact that Justice Kennedy, although he is a swing vote in many cases, he's not the moderate that he's often depicted as being. Rather than being a moderate justice, I would say Justice Kennedy is an unpredictable extremist. Whichever way he swings in a given case, he tends to go all in, whole hog. And in this case, Kennedy joined a dissent jointly authored by the 4 dissenting justices, Kennedy, Scalia, Alito, and Thomas, that took a very radical position that would have struck down the entire health care law, all of it, even provisions that weren't challenged as unconstitutional, on the theory that because some of the key provisions in the dissenters' view were unconstitutional, they have to throw the whole thing out because they have no idea whether Congress would have enacted the law without the provisions they thought were unconstitutional. Indeed, even the one minor respect in which the majority limited the law by saying that the Chief Justice Roberts' majority opinion, even though he upholds the law essentially, he did say that Congress could not threaten to cut off funding that the states currently receive for the Medicaid program if they decline to participate in the expanded Medicaid program under the law. Most observers think that's not particularly important. First of all, the law did not mandate that states would face a total penalty of total cutoff if they didn't participate. It arguably gave discretion to the Secretary of Health and Human Services to impose a penalty like that. In all likelihood, it would have been politically inconceivable that Secretary Sebelius would actually take such a draconian step. And furthermore, it's overwhelmingly likely that most states are going to participate anyway because it's too good an offer to pass up. So this was a fairly minor adjustment in the law to say that the court essentially ruled out the possibility that this draconian penalty might be applied to the states. Well, the 4 dissenting justices said that because the majority took away this one potential draconian penalty, which is unlikely to really affect the practical expansion of the health care program anyway, that required the court to throw out the entire Medicaid expansion. A truly bizarre and extreme position.
What did this decision hinge on?
It hinged on the tax power, and this was another big surprise in the case. In addition to the roles of Chief Justice Roberts and Justice Kennedy, I think what law students, and what anyone who's interested in the law might pay attention to here, is that the majority upheld the law not on the basis of Congress's commerce power, which was what all the shouting was about and all the controversy was about. Rather, the majority, Chief Justice Roberts and the majority, invoked the sleeper issue in the case, Congress's power to tax. Now, a lot of people might say, what does Congress's power to tax have to do with the health care law? Congress was expanding health care. They weren't imposing taxes. There are actually quite a few taxes imposed in the health care law, and furthermore, the so-called individual mandate in the law, which is the most famous provision that says almost every American has to buy private health insurance if they're not getting it through their employer or from the government already. that individual mandate is enforced by a penalty. Congress calls it a penalty, quote unquote, and that penalty is collected on your tax return by the IRS. The majority said, essentially, this walks like a tax, quacks like a tax, IRS collects it like a tax, therefore it's within Congress's tax power. And by the way, if a person doesn't comply with the individual mandate, there's no penalty or no punishment other than that this financial penalty will be collected on their tax return. If you don't file a tax return, you're off the hook. The government can't come after you and prosecute you. They can't put a levy on your property. And so it's the so-called individual mandate is really a mandate that says if you don't buy health insurance, you'll pay a tax penalty. And the majority said it is sufficient to uphold this as an exercise of the tax power. Now, this was always argued in the case, was always part of the case. It was always clear to students who study constitutional law that Congress's tax power is extremely broad. But because that was the kind of more boring or the less exciting or controversial issue, it tended to get overlooked. Because the majority said this case hinges on the tax power, all of the shouting and all of the controversy about Congress's commerce power for purposes of this case becomes an academic sideshow. It's what lawyers call dicta. It's irrelevant to the decision. Interesting, may have some persuasive effect in future cases, but all of the discussion of the commerce power is irrelevant. This turns out to be a tax power case. And with regard to the Medicaid expansion issue, it's a spending power case. So when I teach the case in my con law class, I'm going to make it the lead-off case when we study the tax power and the spending power, and then throw in maybe a little bit of discussion, what might this mean down the road when it comes to the commerce power? But that's not the main story because of the way Roberts wrote the opinion.
Is there anything else you would like to say about the Affordable Care Act decision?
Well, I guess in legal terms and constitutional terms, I would say it's a reminder that the Supreme Court ultimately tends to be deferential to Congress when Congress passes social and economic legislation, or when the states pass that kind of legislation. The court views its role as not to really monitor or control social and economic policy, but to police the outer limits of the Constitution. Historically, the court has gone off the rails and has misjudged its power when it has intervened too much in controversial social and economic legislative issues. I think in this decision, Chief Justice Roberts and the majority wisely kept the court out of that political issue. They'll let Congress and the presidential candidates fight it out on the election trail rather than trying to judicially dictate the outcome here. And that, I think, is the important message.